Hey guys, we're going to go over the amended judgment of conviction for Darrell Brooks. Under Wisconsin Law 972.13, a judgment of conviction shall be entered upon a verdict of guilty, and it will be in writing according to the statute. The judgment shall set forth the verdict, the adjudication, and the sentence. So the Clerk of Court has sent me the amended judgment of conviction, which serves as the final order for purpose of appeal as well, which is still waiting on transcripts before that process really begins. So let's go over what the actual written order is, no guessing about it, what the actual language is, and see what the judge entered into the record as the sentence against Darrell Brooks and provisions against him. The order was entered on April 14th after the last restitution hearing, which resulted in amendments to the original judgment of conviction. Page 1 sets out the first 6 counts. Those are first-degree intentional homicide, and states the defendant is guilty of all 6 counts through trial by jury. Page 2 starts out strong on count 1, noting a sentence of life. Defendant is credited with 360 days time served. That's the good news. He got that first, I guess. The bad news says he's not eligible for extended supervision, a new age term for parole. And so the 360 days doesn't really help, does it? The second entry for count 1 is for cost, and it notes that costs must be paid as a condition of the sentence. You'll see that throughout this order. Well, since Brooks is never eligible to come out, you could imagine his motivation to clear this or any debt is quite low, as it always has been through his life. The next entry for count 1 is entitled restitution. It appears all the restitution items are listed under this count 1 rather than apportioned to each applicable victim's charge. Of course, restitution is just a tiny fraction of the damage he caused. It doesn't represent at all what he did. Nevertheless, let's go through it. And so they include $47,193.29 for EMC Insurance Company on behalf of the Waukesha School District. And you'll note that most of these are insurance companies' subrogation claims. The next one is $124,220.65 to the Crime Victim Compensation Fund. That is the state program that provides some restitution to victims of crime we talked about in a previous video. The monies are to be collected from prison monies, quote, pursuant to statutory provisions, end quote. The court also finds an escrow account appropriate under section 949.165. So that is the Son of Sam law that requires payments related to movies, books, TV, radio, etc. about the crime be turned over to the Department of Corrections and held in escrow to be distributed with priority to legal representation first, money judgments by victims against Brooks, and restitution third. We talked in an earlier video about the legal issues that have hit some Son of Sam laws, but I haven't seen Wisconsin subject to an appellate level ruling, so I won't get back into it. If you're interested, you can go back and watch it. As far as I know, this current law stands. Now, the judgment starts with the amendment part, adding $10,246.20 to the Crime Victim Compensation Fund claim, so they've paid out some more money to victims, or found out about it at least. Hartford Insurance for victim B is set at $108,164.61. Optum subrogation for victim OO was set at $118,805.62. Progressive Insurance for victim GGG was set at $10,000. Progressive Insurance for victim Q was set at $104,662.64. The court notes these additional amounts must be paid as originally stated above. So from that list, you can see obviously almost no victims are making claims under this, and basically the ones that are represented are through their insurance companies. So again, the restitution is not representative of the damage he caused. The next entry for count 1 is labeled Other Sentence and requires Brooks to provide a DNA sample if that hasn't been done already. It has further terms that don't apply, including that if he's discharged with remaining financial obligations, a civil money judgment would be entered against him. And it notes collections can include income assignment. Counts 2 through 6 then follow, noting life sentences with no eligibility for extended supervision or parole, and cost being a condition of the sentences. Page 3 then notes that each life sentence will be consecutive and not concurrent. So concurrent is they run together. Consecutive is one sentence starts after the first one finishes. The financial conditions are summarized as $978 for court costs, $513,293.01 for restitution, $51,407.30 for other. This is starting to sound like a cable bill or a phone bill. Victim witness surcharge, $552, 5% restitution surcharge, $28,257.02 in DNA analysis surcharge of $1,500. The order then notes that he is not eligible for the substance abuse program or the challenge incarceration program. The challenge program appears to be like a form of boot camp, and if you do it, you can earn credit towards your sentence, but he can't come out, so he doesn't need to be doing that. Note, the order then states that if Brooks is in state prison, which he is, it's ordered that the defendant authorizes the Department of Corrections to collect from the defendant's wages and from other monies held in the defendant's inmate account an amount or percentage which the department determines is reasonable for restitution of victims. This tracks with the state statute that says this is what the court will order. Now, as to how much that is, I've shown and will show again the Department of Corrections policy on this. You can see restitution is in there at a max of 50%, and that level has been held appropriate in appellate cases. See earlier video. But the judge did mention 25%, and maybe that's covered under the 25% max income assignment that you also see on this chart. I'm not sure. At any rate, the relation between the source of funds, who has the funds, is it in the inmate account or somewhere else, and the Department of Corrections' ability to take some of it, it's all quite complicated. And wages, gifts, and say potential payments for his story, which hopefully doesn't happen, or inheritance, are all subject to varying rules. And of course, if someone gets a civil money judgment, that has different collection methods than inmate account deduction. So it's not so straightforward as people would wish it would be. I've covered it in a couple videos prior in terms of what those various laws are and the differences to some degree between money judgment collection and inmate deduction and stuff. We're here for the order, so let's move on. This is noted to be a final order for purposes of appeal. Brooks' appeal attorney is still waiting for the transcripts, which have been delayed. And once those get in, he files additional paperwork to notice the appeal formally. He then has certain deadlines to meet, but those are routinely extended. I already did another video on the appeal process and how long it takes, potential timelines. I won't beat that dead horse again here. It takes a long time. Even a no merit report typically takes a long time. So the order gets distributed to the judge, the appellate counsel, Brooks at his Dodge location, DA Opper, and the Department of Corrections. Page 4. This notes the electronic signature and then begins the task of accounting for charges 7 through 75. Charges are set out for recklessly endangering safety in the first degree, and that continues on pages 5 and 6. All right, then it winds up on page 7, and we finally get to charges 68 through 73. Those are hit and run involving death. Charge 74 and 75, bail jumping. Page 7 then notes that Brooks is adjudicated guilty and sentenced as follows. For the first degree recklessly endangering, he got prison time with extended supervision, a total of 17 years and 6 months each. This carries on to page 9. There are so many. All right. And we see he gets state prison and extended supervision, and that's 17 years, 6 months each. And let's see. For the hit and run involving death, he gets 25 years each count, prison and extended supervision, and bail jumping 6 years, somehow going to be split between those two as well. You see toward the bottom of the page, it says total bifurcated sentence time. Because these sentences are bifurcated, that means they're split between jail and extended supervision. Again, that's just parole. The bifurcation section begins. And it notes that each first-degree reckless endangerment is a sentence of 12 years, 6 months in prison, 5 years parole. This carries on to page 11. Let's get there. All right. The hit and run involving death is set at 15 years prison each, 10 years extended supervision. Bail jumping is 3 years prison, 3 years extended supervision each. But then follows the concurrent with and the consecutive information. Remember, the life sentences were consecutive, not concurrent. The first count of recklessly endangering safety is made consecutive to any other sentence and counts 8 through 67. The rest of these are made consecutive with any other sentence and counts 7 through 67. Go on to the next page, and we see a little bit of bright news there for Brooks. Not that any of it matters at all. The hit and run charges are made concurrent with the life sentence of each associated first-degree homicide. Finally, the bail jumping charges are made consecutive to all other counts, but concurrent with each other. So there's a lot of consecutive with just a little hint, sprinkling of concurrent baked in. Page 13 sets out the financial obligations for these counts. $11,410 court cost, other of $910. The victim witness surcharge, $6,440, and DNA analysis surcharge of $17,500. Under count 7, we see cost payments are made a condition of the sentence with the same type language of a civil judgment, give us DNA and all that as you saw in the earlier count 1. We also see Brooks is ordered, however, here, no contact with any victims listed on the amended victim identification key, and also Erica Patterson. The page continues on, goes on to page 14, noting for each account that cost payment is a condition of the sentence. At the first hit and run count on page 14, the court repeats the prior information on payment and no contact with victims and Erica Patterson. But then repeats toward the bottom that he's not eligible for this boot camp thing or substance abuse, and it has the same language repeated that the DOC may collect from wages and other monies held in Brooks' inmate account an amount or percentage which the department determines is reasonable. And the final page notes the order on these charges is final. So when his appellate attorney files an appeal, he's going to look to this as one of the documents he's got examined before he gets into the whole transcript and potential reversible error and stuff. So rather than try and guess and remember and all of that, I actually have the judgment, and I've tried to put the pages up so you can clip them if you want it or refer back to it at any point to see what was actually ordered for each of these things if his case does ever move into an appeal phase where it warrants looking at it again. That'll be a while, but hopefully it results in a no merit by his attorney, and that's that. But I guess we'll see, and maybe hear no more from this. Well, the next thing probably is going to be the transcripts are due, I think, in early May. Will they be extended again, or they actually come out and then the attorney file the paperwork he's supposed to file? Or will he finally get to these other trials he's got first? I don't know the answer to that, but that's this order. That's it for today. Thanks, bye.